Partial funding for this program has been provided by the Radio and TV News Endowment, a fund established by listeners and viewers to sustain reporting of Indiana news. More information at indianapublicmedia.org/support. And by WTIU members. Thank you.
Good evening, I'm Barbara Brozier. The Sixth Amendment guarantees citizens the right to representation if they're accused of a crime. It's a constitutional protection meant to ensure everyone gets a defense regardless of their ability to pay. Every day, people across Indiana face felony and misdemeanor charges in their county courtrooms, but only a small number of them can afford to hire an attorney. We assume someone will be there to represent us because the Constitution promises us that. But some legal experts say the term justice for all may be more accurately described as justice for few.
The liberty that we cherish so much and enjoy, really, it is dangling by a slender thread.
They work for the state. Their caseload is way too high for them to give any adequate representation to anyone.
Public defense systems in so many of the states around the country, including Indiana, I fear, is failing.
If you get arrested, your odds of getting an independent lawyer are extremely slim.
William Carey is trying to hold it together.
I'm just tore up. I don't know what else to say.
He just came out of the Johnson County Courthouse where he appeared for a pretrial hearing. Carey faces several charges, including operating a vehicle while intoxicated as a habitual offender. Today, an attorney with the Johnson County Prosecutor's Office offered him a plea deal.
I don't know what to do because I have no attorney. You know, what's going through my head is my freedom. You know, this is my life. And they're going to give me 8 years. You know, either sign this or I'm giving you 8 years. So I had no choice.
Carey had no legal representation because the judge determined at a previous hearing he isn't indigent and therefore doesn't qualify for a public defender. Now, Carey broached that subject again at a November hearing, telling the judge he only makes $250 a week and therefore can't afford to hire an attorney. Now, we were inside the courtroom at the time, but Indiana law doesn't allow cameras in the courtroom, so we can't show you what happened. We can, however, tell you based on transcripts from that hearing.
Because you've got no expenses, you were living with your parents.
Well,
They are feeding you. They are housing you.
I help them out with groceries, you know.
No, I'm not buying that. You live at home. Your parents are taking care of you. That's the way it works. I'm not stupid.
I'm not saying...
So what are you going to do with all the money instead of hiring a lawyer, which you said you were going to do?
I'm just, you know, expenses.
So Carey says he signed the plea agreement. He agreed to plead guilty in exchange for the state dropping some of the charges against him because he saw it as his only option.
It was wrong. I have no legal representation. I don't know nothing about the court system.
Indiana doesn't have a statewide standard to determine whether someone qualifies for a public defender. It's left up to each individual judge to make that decision through a series of questions. Johnson County Superior Court Judge Lance Hamner says he doesn't think that's a problem. He's confident those who qualify for a public defender, at least in his county, are granted one.
We'll hold a hearing and make a determination based on their income, based on the family income, based on the resources they have available to them, for example, the property they own and things like that, to determine whether, as a matter of law, whether they are indigent.
But some legal experts say the definition of indigent is too broad and is applied inconsistently. It means someone who might qualify for a public defender in one county could be denied representation in another.
The test in Indiana is called the substantial hardship test, and it simply means, can the person accused of a crime afford to hire a lawyer without imposing a substantial hardship on himself or his family? And there is no, simple objective test of how much income or assets do you have, because it depends often on the severity of the case.
And that's not the only way public defense differs across Indiana. Yes, the Constitution requires states to provide public defense systems for their citizens, but Indiana passes that responsibility on to the counties and leaves it up to them to deliver on the promise. That means there's a lack of consistency across the state, and some argue a lack of quality.
We've got a system that is broke.
The legislature set up the Indiana Public Defender Commission in 1989, which establishes standards for indigent defense. It offers a reimbursement program for counties. If the county agrees to follow standards set forth by the commission, it could be reimbursed for up to 40% of the costs of non-death penalty felony cases. But just more than half of the state's 92 counties abide by the standards necessary to qualify. Some counties in the program aren't eligible for reimbursements, and just about 1/3 of the counties in the state don't participate at all.
Counties don't like to take state money because they perceive strings attached to it, even though the strings are really protecting the public defenders, the quality of representation, because you have caseload standards, compensation standards, experience requirements for certain kind of appointments.
The commission standards vary based on how much of a support staff the public defender has and what type of case they're defending. A full-time public defender with adequate support staff can take on as many as 150 felony cases in a year, while a public defender with fewer resources can take on up to 120 cases. The limits are higher for lower-level felonies and misdemeanors.
There are a number of very good lawyers, and in many places, the best criminal defense lawyers are public defenders. But if you take the best lawyer and you handcuff their hands behind their back and you blindfold them and you give them no resources and throw them in the ring, what are you going to expect? You're not going to expect high performance.
Johnson County is among those not participating in the state's reimbursement program. That means it doesn't have to comply with things like training and caseload requirements. Judges contract with private attorneys here to handle public defense cases in their courtrooms.
We would never tolerate a judge being an employee of a prosecutor or a prosecutor being an employee of a judge. But for some reason, we tolerate the advocate for the accused person to be an at-will employee of the judge. And then if you want to take an appeal, and you usually on appeal are alleging that the judge made a mistake, did something wrong, denied the defendant a fair trial, you got to appeal your boss and claim that the boss screwed up.
The judges in our county, and myself included, expect zealous representation on the part of the attorneys that we appoint as public defenders. I would never expect them to back down in any way from us in any way. We wouldn't ask them to, we wouldn't want them to.
Johnson County Prosecutor Bradley Cooper doesn't see a problem with the inconsistencies in the public defense system. He says the attorneys who represent indigent defendants here are among the best.
Whether you're poor or rich, you have the same set of constitutional rights. And those constitutional rights, at least in this county, are absolutely given to everybody that comes before the court.
But two lawyers are appealing a recently dismissed lawsuit that claims Johnson County is failing to fairly represent people facing charges here.
The major problem in Johnson County is that it's a system of graft, and the judges turn a blind eye to the complete ineptitude of their attorneys, of their public defenders.
Among the allegations listed in the suit, there's no oversight of Johnson County's public defense system, and public defenders don't devote the necessary time to each case. The lawsuit claims, in one instance, a part-time public defender in Johnson County was assigned more than double the maximum number of cases allowed by the state's Public Defender Commission.
What our clients experienced in this lawsuit is sitting in jail for months without ever seeing their attorney. They would see him in court for a minute or two where the attorney would ask for a continuance, and then the attorneys do literally nothing.
The facts spoke for themselves. It was a pretty atrocious program down there.
But Cooper says the fact the lawsuit was dismissed speaks for itself.
I thought the lawsuit was ridiculous, yes.
But it isn't the only lawsuit challenging the quality of public defense in Indiana. Here in Allen County, several defendants have filed a lawsuit in federal court, alleging they didn't receive adequate representation here. And some argue the problems aren't confined to one county.
It's not about bad lawyers. It's about they have no resources, they have no independence, they have inadequate compensation, excessive caseloads. It's going to impair quality of representation, and it does.
guy that's been here so bad.
Asia Marshall thought she was on the path to success.
I've never been in trouble. I worked for community corrections. I have a bachelor's degree in criminal justice and an associate's in human services.
The single mother worked hard to get an education and start a career so she could not only provide for her family, but also serve as a role model.
I purchased a house at 30 in Arlington Park. I mean, I had high standards and I was on a path of high, moving up, motivated.
But her path drastically changed in December 2014.
I was arrested for domestic battery, misdemeanor.
According to court documents, Marshall's boyfriend at the time called 911, claiming she hit him in the face with a remote, causing him to bleed. When police arrived, he told them he didn't want Marshall arrested, but still, she was taken into custody and charged with domestic battery and disorderly conduct. Marshall maintains her innocence and fought the charges for a couple of months with the help of a private attorney. When she ran out of money, a judge assigned her case a public defender. And that's when Marshall says the problems started.
I basically was my own attorney and handed him everything. And he still didn't have the time or the means, and he still provided me a defenseless trial.
A jury convicted Marshall of both charges. It was her son's birthday, and she was sent off to jail.
We had his party scheduled for Jungle George's, had him a nice cake and everything.
Because of what happened at her trial, Marshall is part of a class action lawsuit that alleges Allen County's public defense system is inadequate. The lawsuit says her public defender called no witnesses, introduced no evidence, and refused to let her testify during the trial. Marshall says she was repeatedly pressured to take a plea deal, but she refused because she says she's innocent.
To me, they're plea pushers. It's easy to push a plea. I don't have to research this case. I just make this sweetness deal and make this sound good from a person. The average person does not want to fight.
Attorney David Frank is representing the class action lawsuit against Allen County. He says some of the public defenders here have been assigned as many as 4 times the maximum number of misdemeanor cases allowed by state standards. The lawsuit claims, as a result, the part-time public defenders can't devote the necessary time to most cases.
It's embarrassment to the state, but more importantly, it's causing the incarceration, the needless incarceration, and devastation of lives of the poor. And somehow no one wants to talk about that. That's the population being affected.
An Indiana University McKinney School of Law professor recently penned an expert report supporting the claims in the lawsuit. He writes the caseloads in Allen County are, in his words, much too high and therefore pose an unacceptably high risk that many of the clients represented by these lawyers will not receive reasonably effective assistance of counsel.
They are really asked to provide representation in circumstances where they don't have the resources, they don't have adequate compensation, and they so often have truly outrageous caseloads. And as a result, they wind up practicing law in ways that they would never do if their client had adequate financial resources to provide compensation and to pay for the auxiliary support services that are necessary in public defense.
Allen County does participate in the reimbursement program through the Indiana Public Defender Commission, which means it has to comply with training and caseload requirements. But the rules only apply in felony cases. So in misdemeanor cases like Marshall's, there's essentially no way to hold counties accountable for the quality of public defense they provide.
If you have a county that is theoretically constitutionally obligated to provide a service to poor people, but if they don't, there's no consequences, what do you think a county is going to do? They're not going to do anything because they don't have to.
That was one of the top findings in a report by the Sixth Amendment Center, a national nonpartisan group that advocates for the indigent.
There's a lot of collateral consequences that come from a conviction on a misdemeanor, and yet counties and cities are not held to any sort of standards, and for the most part, they're providing services by contracting with a single attorney or a group of attorneys to handle an unlimited number of cases. These attorneys spend very little time on these cases, and people are ending up with very serious life consequences because of it.
The report says outrageously high caseloads for public defenders are a problem throughout the state. It says in 2014, some Elkhart County public defenders had as many as 5 times the maximum allowed cases in a year. That same year in Marion County, one attorney had a caseload that was more than 3 times the cap.
And the program needs to be adequately funded with the general revenues of the state.
Those statistics led several attorneys to file a petition last year asking the Indiana Supreme Court to spell out rules, procedures, and standards for defending the state's indigent. And it asked the court to establish a statewide public defender system.
Indiana is at the lower half of the 50 states. So you take a state like Louisiana, where people may have been reading about all the indigent defense problems there and people going without counsel. Well, Louisiana currently spends $66 million a year on indigent defense, and they have less of a population than Indiana.
The financial resources overall that are provided in Indiana for public defense services are simply inadequate. And you cannot have a first-class system of public defense unless you have the appropriate structures in place to assure that the defense representation that is provided is both competent and effective.
The judge is paid for by state money. The prosecutor's office is funded by state money. Nothing is funded from the state regarding public defenders at all. So that sort of, by allocation of money, makes it an unfair fight.
Indiana lawmakers could look to other states like Kentucky for ideas on how to fix the public defense system. But even states with a centralized system face some of the same challenges. The sun hasn't been up long in Carrollton, Kentucky, but Sarah Wiedenhafer is already well into her workday.
I think ultimately the big draw for me is that it's an opportunity to give back.
Wiedenhafer works as a public defender in Kentucky, which has a statewide system for indigent defense called the Department of Public Advocacy. She's one of 11 attorneys who works out of the Boone County office, and today she's spending her morning in Carroll County District Court.
So no change in the bond, Your Honor?
The majority of the people appearing in court today are Wiedenhafer's clients. She bounces from one case to the next, greeting each person with a smile and asking the judge to consider setting or lowering the bond for clients who are currently in jail. It's dizzying to watch her manage it all. And while she makes it look easy, she says it isn't.
I think the biggest issue is always going to be managing the time with the demands.
Wiedenhafer handled so many new and old cases on this day, we couldn't keep track of them all. According to the Kentucky Department of Public Advocacy's annual report from last year, the number of new trial cases has jumped nearly 15% in the past 10 years. The state's governor proposed a budget last year that would have added 44 more attorneys to help deal with the increase in caseloads, but legislators slashed it from the budget, so caseloads aren't getting any easier to manage. Last year, Kentucky public defender caseloads averaged about 55% above national standards. It's an issue public defenders across the nation are grappling with, regardless of how their system's set up. But the Boston-based nonprofit Sixth Amendment Center says a statewide system like Kentucky's is better than a state like Indiana's because it provides more oversight of public defense services. The center listed several recommendations to improve Indiana's public defense services, which currently vary from county to county.
The level of justice people receive very well can depend on what side of a county line your crime is alleged to have been committed.
The report says Indiana's public defense system is inherently flawed because it both institutionalizes and legitimizes the choice of counties to not fulfill the minimum parameters of effective representation. Counties are free to, and do, forego state money in order to avoid oversight. Some of the other recommendations include creating a mandatory training and supervision system and a system to ensure compliance with all standards. It also suggests creating a statewide appellate defender office, which is something Illinois has. But some question whether adopting a centralized public defender system is best for Hoosiers.
I think that every county by size, by the nature of its population, rural, suburban, urban, has different situations. And I think that anytime we try to do a state down, one size fits all thing, we run into the possibility of waste. We run into the possibility of overshooting the runway.
Bud Herron is part of the 3-member Public Defender Board in Bartholomew County. The county created the board last year and tasked it with coming up with recommendations for improving the public defense system here.
We have, by estimate, 200 more cases that moved through in 16 than moved through in 15 that required public defenders.
Bartholomew County is trying to be proactive about the problem, especially after hearing about the lawsuits filed in Johnson and Allen counties, alleging their systems are violating people's constitutional rights through inadequate representation.
We don't want that to happen here, not just because we don't want the expense of it, we don't want the possibility of retrying cases that were considered not adequately represented. We want to do it because it's the right thing to do, and because the people deserve this.
Rather than going all in and complying with the Commission standards in order to qualify for reimbursements, the board is recommending Bartholomew County fix what it already has in place. Here, judges appoint one of 11 part-time public defenders to handle cases. But under the board's recommendations, that would change. They want the county to hire 2 more part-time public defenders, as well as a chief public defender who would oversee and appoint them. They say it could eliminate any potential conflicts of interest.
It's something that neither the judges nor the attorneys want to be involved in, just because it casts an ethical cloud over our judiciary. And if there's anything in this country that we need for sure to have the very highest of respect and the highest of accountability, it's the judiciary.
Herron says the biggest hurdle is getting the county to approve the funding needed to implement the recommendations, which would cost thousands of dollars. And that may be the biggest challenge facing the system as a whole. According to the most recent information available from the Department of Justice, in 2012, state governments only spent $2.29 billion nationally on indigent defense. That may sound like a lot of money, but in reality, it's only 10% of their judicial budgets.
We can always use more money, more people, more space. We're out of space.
The Monroe County Public Defender's Office has one of the most robust systems in Indiana. The office has 15 full-time attorneys on staff, but Chief Public Defender Michael Hunt says it wasn't easy to get here.
When I tried to get into the state reimbursement program, it meant that we needed more attorneys to meet the caseload standards. That required the county council to hire more people, and I got 3 or 4 years of pushback where they wouldn't let me apply until I basically had saved enough money from fees we get to hire a couple of attorneys.
Hunt says he can't speak for other counties, but he's pretty happy with the type of public defense provided here. Because Monroe County has a public defender office, there's also support staff to help with the time-consuming tasks associated with defending cases, like hiring an investigator. That's a luxury many counties in Indiana don't have.
So the only purpose for the stop would have been the expired tax.
Back in Kentucky, Wiedenhafer says that's one of the biggest benefits of a statewide public defense system. There are more resources for attorneys representing the indigent here.
I think there is absolutely an argument to be made that the state-run system provides more consistency, if from no other standpoint than the training that we as attorneys representing the defendants receive and the expectations that are on us as far as trying to advocate their best interests.
You may be wondering what happened to 2 of the people we mentioned in our report. As part of a plea agreement, a judge sentenced William Carey to just over 700 days in jail. That sentence was later modified to just over 450 days of work release. And Asia Marshall, one of the defendants in the Allen County lawsuit, recently had a development in her criminal case. The Court of Appeals vacated her disorderly conduct charge, saying she was being prosecuted twice for the same thing. Now, Marshall wanted the Indiana Supreme Court to take the case up, but it declined to do so. While those criminal cases are resolved, the lawsuits against Johnson and Allen counties aren't, and both Marshall and Carey are left questioning a system built on the premise of fairness.
What they took from me, they took my money, they took my family, they caused me a lot of deaths in my life that will weaken a person and cause a person to break down.
Now, it's hard to put an accurate number on just how much money the state of Indiana spends on indigent defense, and that's because there isn't a statewide system in place. Any significant changes to the system would likely require significant money. That means this is an issue the legislature would have to take up. Whether anyone will champion the cause remains to be seen. Thanks for joining us for this special report. Have a great night.
Partial funding for this program has been provided by the Radio and TV News Endowment, a fund established by listeners and viewers to sustain reporting of Indiana news. More information at indianapublicmedia.org/support. And by WTIU members. Thank you.